Content application.
Give.
Apply Lordship. Content application.
Inclusion.
Yes.
Item number 1.
Lordship seeking a short pass over Lordship. Mr. Chatterjee is engaging another court, Your Lordship.
There are today it is posted for order 3 issues. Lordship, the petitioner is facing the criminal charges. Now, whether it can be termed as moral turpitude or not, that was my first limb of argument. And Your Lordship expressed Your Lordship's opinion that on the basis of the authorities that since the term moral turpitude, it's vague term, and here also the matter is connected with some of the offences which could be termed as moral turpitude. But Your Lordship has also expressed the prima facie opinion regarding the facts that what is the entitlement of this person during the pendency of the criminal trial to get the retiral dues. And Lordship, I have drawn Your Lordship's attention to the Rule 14, Rule 8, Rule 10 of DCRB rules and 71 rules. And it was shown that in the 71 rules, unlike the rules of Jharkhand, Bihar, we don't have that. We have that clause regarding the pendency. It should be cartel. The percentage is there. Now, Lordship,
The enabling provision.
enabling provision is there. And apart from that, there was a point raised by my learned senior friend appearing on behalf of the state that whether the gratuity is covered by pension. Then, Lordship, I have cited the order of a learned single bench of this Honorable Court, passed by Justice Dotto, where it is stated that Rule 8, Rule 10, and Rule 14, the language is different in Rule 14. The word gratuity is not mentioned in Rule 14, and that judgment has been deferred. So, Lordship, in the view of that, I prayed for the release of my retiral dues. I am not getting any retiral dues. The pension, I'm getting that total amount of pension. So far, gratuity is concerned, I have not got that gratuity, and leave encashment, I'm not getting.
Trial is regarding that loan, availing the
Loan
loan
availing
facility
the-
in the name of the builder. And all.
He has, so far that is concerned, his role is very limited. Nothing is there. But trial is also not proceeding. That apart, Lordship,
That is still pending. There is
that
no.
is still pending. It's admitted position here. And rule is also not challenged. That is also an admitted.
Which was the rule under which they were seeking to withhold?
Lordship, there is Rule 14 of DCRB 1971. DCRB 1971 is.
Now we remember you had argued this. Elaborately, you have.
We have argued elaborately, Lordship, this. Rule 14 of DCIB rules, Lordship, it talks about criminal proceeding. A government servant,
So two-third is being granted to you.
Lordship,
Two-third is being granted to you.
two-third is provisionally it is being granted to me. A government servant who retires from service but against whom criminal proceeding involving moral turpitude are pending in a court of law shall not be sanctioned any pension until the termination of the criminal proceedings. An interim allowance not exceeding two-thirds of the pension that granted during pendency of such proceedings in cases of hardship. If he is convicted on a criminal charge involving moral turpitude, he shall not be entitled to any pension. Compassionate allowance may be granted subject to the same terms and conditions as laid down in the Rule 12. Now, Lordship, Rule 12 says misconduct or inefficiency. No, it's not a case of misconduct or inefficiency because it is also an admitted position here. No departmental proceeding was initiated against me. He was continuing the service, and Rule 10, this talks about the right to hold pension in certain cases. And here, Lordship, Rule 10 says, the governor reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, or the right of ordering the recovery from a pension of the whole or part of the pecuniary loss caused by the government if the pensioner is found in a departmental or judicial proceeding to have been guilty to grave misconduct, negligence.
So 10 appears to be operating in a case where the allegations are linked to the service.
So it is also not the case. Now, my learned senior friend, Mr. Mukherjee, submitted, placed his reliance on Rule 8.
8, yes. Pension
This is
includes
withholding the pension in cases of conviction and misconduct. Future good conduct shall be an implied condition for every grant of pension. The pension sanctioning authority may, by order in writing, withhold or withdraw, either in full or in part, a pension or gratuity, or both.
He has relied on 14, but he has said that 14 is the enabling provision. Mr. Mukherjee has argued that 14 is the enabling provision for withholding the pension during
Yes.
pendency.
But I say 8 is the
If
enabling.
it is read along with Rule 8,
8.
then gratuity is also to be withheld. That is what he was submitting.
His submission, my submission is that on the basis of the learned single judge decision, that this is not covered by that, because here pension and gratuity, both the words are mentioned. In Rule 14,
It is only pension. There is no
Yes.
mention of the
Yes.
word gratuity, and that is what the
the learned
judgment is
single
on.
judge also held.
And just give us a few details. What is your date of retirement?
My lord, my date of retirement is
And he is not disputing that you are entitled to full amount of leave encashment, group insurance, provident fund. That
he is not disclosed. 31st July 2020. He retired.
July 2000,
20.
retired from which post?
Yes. My lord,
Retired from which post?
my lord, retired as upper division UD, upper division assistant. Upper division assistant. And he availed all promotions also. And Lordship, the impugned order passed by the tribunal, which reflects the interprets Rule 14, is clear that a government employee involved in any criminal proceeding will not be entitled for pension and any other admissible dues. It is not in dispute that a government employee was arrested and set of criminal charges framed against him. During his period of suspension, he was paid the subsistence allowance, and after review, such suspension was lifted and he was allowed to continue. The criminal case is
So his arrest was during service,
service.
Service.
and there must have been automatic suspension and
Yeah,
revoked
automatic
Suspension. That's
Deemed
option.
suspension.
deemed automatic
But
suspension.
he was
And after coming out,
assumed the
revoked.
service. He was allowed to assume. Very good. Now, this observation on the basis of which this application was dismissed by the tribunal is also wrong, because it includes that all other admissible dues along with the pension.
That is what we have to resolve.
When I've said
According to
that,
Mr. Mukherjee, it in 8 makes it clear that pension includes
My lord.
gratuity, and therefore 14 read with 8 means that both can be withheld.
but not the leave encashment and mother
Group
property.
insurance and provident fund.
That
That you have said he is entitled to full.
we have not disputed because that has not been said in the
And
rules.
pension 2/3,
Yeah.
2/3 only. Yes.
Item number 2. I'm for the respondent number 5.
My lord, in this matter, Mr. Sukhruddin Gaur is appearing, my lord, I am playing for short possible.
My lord will kindly make it. If the event Lordship is making it Passover, kindly makes it not today. Lordship had heard it to some extent yesterday.
Want to be decided whether
Whether I could be compelled to insert the name of my wife and daughter in my service book. And the names were inserted after I got the job, at least 10 years prior to when I got married.
Yes. What is the, you are supposed to show, address us?
Kindly make it short possible, my lord, just my lord, he is on left.
Oh, no, not at all. No password.
Actually, my lord,
Abhishek
Yes.
Das. Who can file the nomination?
West Bengal service rules.
in the
Nomination can be filed only by the employee, not by the first wife or second.
Correct, that we have seen yesterday.
Yes, sir.
And the family is defined
Family is
and
different.
beneficiary has to be one amongst the family and the beneficiary can be one or more than one family
than
member. Or it can be one after the other also.
Yes. My lord,
That is
And
for,
that is the choice of the
that
employee.
is for the employee to specify.
It
Yes.
is the choice of
in
the.
this case, my lord,
I have taken print.
The
short print
mother-
out.
mother and the sisters have been incorporated.
Correct.
Sister has been, my lord, incorporated as daughter. My lord, kindly see, my lord, page 57. Page 57, my lord, the reply, my lord, issued by the authority
এখানে একটা error আছে।
that as per service book, Constable 1488 Gautam Das has entered Kumari Subhadra Das, Kumari Mamoni Das as his daughters. But admittedly, my lord, they are the sister, as would be evident, my lord, from the FIR.
No, as his mother in the service.
It's an
No,
admitted error.
not mother, as his daughters.
No, if he, even if he has misrepresented,
Yeah.
then no.
My lord, kindly.
That will not vest a right in you to claim that your name
My
should
lord,
be.
they are not the, my lord, daughter.
That you have said, you need not said 3 times. You have said twice. We have understood, yes.
And my lord, in view of my lord rule 7E of the death come retirement.
17, rule 17, 7E.
After it is after retirement.
Hmm?
After retirement.
What is there in page
Hello,
57
family.
is definitely an inadvertent error.
Everybody will speak side by side. Very unique
I'm
way of
extremely sorry.
appearing in a court. Yes,
Only include
yes,
the following relatives of government servant, namely,
yes.
for the purpose of a death gratuity. My lord, wife in the case of a male officer, husband in the case of a female officer, sons including stepsons, unmarried and widowed daughters. Here, my lord, it is
And 5? What does 5 say?
five.
No, you are reading up to Roman 4. You are not reading Roman 5.
Mother
Therefore,
to the age of 18 years and unmarried.
And
widow.
5 was the brothers below the age of 18 years and unmarried or widowed sister. Well, they have married.
we don't, maybe they will not be
And
eligible.
father, mother.
Maybe.
So, my lord,
We don't know. That is not the
yes,
dispute here. The issue is whether you can compel him to make you a nominee or not. And rather whether you can compel the state that you must be incorporated as a nominee, even though the employee does not want. That is the issue.
my lord, excluding, my lord, the wife and, my lord, the daughter. My lord, he has only included mother and unmarried sister at that point of time.
Yes.
Now they have married. And My lord, there is my lord also provision of 100 regarding nomination. Lord, I will also report you 100. Any government servant to whom these rules apply may, provided he has completed 5 years qualifying service, make a nomination conferring on one or more person the right to receive the death gratuity that may be sanctioned under the time. Provided that if at the time of making nomination, the government servant has a family, the nomination shall not be in favor of any person or persons other than the members of his family. Next, my lord, subclause my lord, if a government servant nominates more than one person under sub-rule 1, he shall specify in the nomination the amount or share payable each of the nominees in such manner as to cover the whole amount of the gratuity. Number 3, a government servant may provide in a nomination that in respect of any specified nominee, in the event of his predeceasing the government servant, the right conferred upon that nominee shall pass to such other member of the government servant family as may be specified in the nomination, and that the nomination shall become invalid in the event of the happening of a contingency specified there. Number 4, the nomination made by a government servant who has no family shall become invalid on his subsequently acquiring a family. And number 5, every nomination shall be in such one of the forms A to B in Annex 2 of this chapter as may be appropriate in the circumstances of the case. Number 6, a government servant may at any time cancel a nomination by sending a notice in writing to the appropriate authority, and government servant shall along with such notice send a fresh nomination made in accordance with. Then minor 7, immediately on the death of a nominee in respect of whom no special provision has been made in the nomination under clause A of sub-rule 3, or on the occurrence of any event by reason of which the nomination becomes invalid in pursuance of clause B of that sub-rule or sub-rule 4, the government servant shall send to the appropriate authority a notice in writing formally cancelling the nomination together with a fresh nomination made in accordance with rule. Number 8, every nomination made and every notice of cancellation given by a government servant under this rule shall be sent to the appropriate authority, who shall immediately on receipt of a nomination countersign it, indicating the date of receipt and keep it under his custody. Then number 9, every nomination made and every notice of cancellation given by a government servant shall, to the extent that it is valid, take effect on the date on which it is received by the authority mentioned. Yes.
Yes. Yeah, I will.
Yes, so
Even for this.
Okay.
Open for this.
Now, my lord, kindly come to Rule 98, the rate of death gratuity. Several litigations crops up in between Rule 100 and 98. 98 also deals with where there is no nomination. when a government servant referred to in Rule 97, who has completed 5 years qualifying service, dies while in service, a death gratuity as prescribed below shall be paid to the person or persons to whom the right to receive the gratuity is conferred by means of a nomination under Rule 100. Provided that if no nomination has been made under Rule 100, or if the nomination made thereunder does not subsist, and if there is one surviving member of the family, the whole amount of gratuity shall be available to him, payable to him. And if the surviving members of the family are more than one, the whole of amount of gratuity shall be payable to all such members in equal shares. The right of a female member of the family or that of a brother of a government servant who dies while in service to receive the share of gratuity shall not be affected. If the female member marries or remarries, or the brother attains the age of 18 years after the death of a government servant and before receiving her or his share of the gratuity. So if I read 7E along with 100 and read with 98, the definition of family, that's been specified. Who are the families? And once, if the brother attains 18, he is excluded. If the sister gets married, she is excluded to become a nominee. Whereas the wife and the daughter are only seeking that our name be placed in the service book as nominees. That inquiry, per se,
So therefore, who is become illegible or ineligible is not the issue. Issue is whether you can seek a compulsion or a direction upon the state to incorporate your name in the service record as a nominee. That is the issue. We are not in the legitimacy of who all is already figuring whether they will get, they will not get, whether it will lapse. That's not the issue here. Whether there is a right or an obligation, corresponding obligation on the state that the wife and daughter's name must be included as a nominee. None of these provisions even suggest so. Because you have approached the tribunal for a direction, directing the respondent authorities to incorporate or include your name. Under which provision? Unless an obligation is cast, then
if
nothing
from
can
the
be-
facts it is crystal clear or admitted that those two sisters who are being nominees in the service book of the employee, they have lost their
Still-
eligibility.
Maybe. Does that cost an
Well,
obligation on the state, which can be enforced through the tribunal or the writ jurisdiction?
authority, that in my subject to correction, in my humble submission, one case has taken place where the employee got married thrice.
That's not the issue. Those are hypothetical that
I'm
hardly arises
relying,
here.
where the honorable division bench is
Yes.
directing the authority
There is a
to
provision.
inquire.
There is a provision that if there is more than one wife, then it can be apportioned. So that is a different context. That's not
No,
neither here
but
nor there.
I bow down.
The
I
issue
bow
is
down.
whether you are to be included in the column for nominee or not. That is all. That is
But
the
I
only
bow
issue.
down. That issue was not before the honorable division bench.
Therefore, that will not apply here.
That whether the amount would be apportioned amongst two wives, that issue was not there.
May not be, but there is a substantial provision to this extent. So that judgment is covered by a provision in the rule. We are asking you which rule obligates the state government to include the name of wife and daughter. Unless there is a duty cast upon them, how you can invoke the tribunal or the writ jurisdiction for such a relief? That is the issue all. We are not on whether the sister is entitled, mother is entitled, not entitled, they may get, they may not get. Well, that is the only issue. There's nothing else. We don't find any such provision. If you can point out, we had asked him on the last day, that is the question we had framed. That if there is any obligation that you must be incorporated and the state can be compelled to incorporate you. We don't find any such provision. So the tribunal has rightly rejected.
Well, in
Whether you
future,
you can invoke other remedies under general civil law, that we don't. And how far it will help you.
Well, this will if an employee puts a stranger's name in
Then
a
he
service
can't.
book.
Then he can't, because it says family. 7 says family.
Well, it's-
And the
that's
family
why
is.
I am not opposing
So
to his
therefore,
mother.
if the stranger's name is there, the stranger will get nothing. Still, does that cast any obligation that they must incorporate your name?
Well, that is the language of the division bench. Division
Let
bench
us see.
is
Show
saying.
us, show us, show us.
Well,
Reference to the
2007 4 SLR 366 division bench. 4 SLR 366 division bench. SCC online টা বললে সুবিধা হবে। হ্যাঁ
এসসিসি অনলাইনটা হলে খুব ভালো
2007 SCC online 880
SCC online. কত কত পেজটা কত
880 sir।
খেয়াল তো
হুম।
খেয়াল তো
হুম।
SCC online খেয়াল হবে।
Honorable Justice Girish Chandra Gupta and Prosenjit Mondal.
আমি লিংকে বলতে থাকতেই পারে। যদি সব যাচ্ছি আসছি হচ্ছে না, এটা মিলিয়ে থাকবে ক্লায়েন্ট আমার স্যার সবার আজকে সেখানটা আমাদের অ্যাবসলিউটলি এমনকি বুক করছে না। না ওটা কি তার রিসোর্সে যেতে হবে তো? হ্যাঁ
Para 4. And it is true that the deceased employee had made entry of the names of the writ applicant and her 2 daughters with the respondent authority to have the benefits of service, such as ration facility, and that he made the writ applicant as his nominee to obtain the death gratuity and other retiral benefits. But so far as the death gratuity is concerned, according to Rule 101 of the West Bengal Services Death Cum Retirement Benefit Rules 1971, the nomination of the employee shall not be in favor of any person or persons other than the members of his family. Here I am emphasizing the marriage of the writ applicant with the deceased constable being void ab initio.
All right.
The entry of the name of the writ applicant as nominee tantamounts to the inclusion of the name of a stranger.
Yes.
Such fact came to light when rival claims were placed before the respondent authority to have the retiral benefits. The respondent authority was therefore within its right in not accepting the claim of the writ applicant, where the second marriage had taken place in the lifetime of the previous
So
wife.
again, we are asking you, how does this judgment support your prayer for a direction upon the respondents to include your name in the nomination?
Well, now both the sisters have become now stranger.
Again, we are asking you, how does it support your claim or prayer for a direction upon the state to include your name as a nominee?
Well, here Honorable Division Bench has intervened and directed that
There is for
The
payment of the pension areas. There is no direction for nomination. Because she is a class of the family members under the rule. And the others are not, they are strangers. Will that give you a right for a direction upon the state to include your name as a nominee? That's the only issue here.
This
There's nothing.
exercise would be ultimately
Maybe we
would
don't,
have to be held.
we don't know. We don't know. We are not at that point yet. That's why we said we are not going into any hypothetical situation. The prayer is for a direction to include you as a nominee.
Well, ultimately, my lord, nominees, my lord,
All right,
my
we
lord,
have
sir,
understood.
very much, my lord, better than me, my lord, is very much aware about the
We don't know. We are
nominees'
not
right,
aware. We are not aware.
right, and the legal heirs' right.
We are not aware.
My lord, nominees' right and the legal heirs' right. Legal heirs'
It's not
right.
the issue here.
That
That is not the issue here. You cannot import those issues in this case. We cannot. Will not permit you. The prayer is a simple prayer. Whether you can have that prayer, the tribunal says no. What is wrong? Nothing is
my
wrong.
lord, I'll be relying on another judgment, my lord, that is of Porosh Chandra Ghosh, my lord, 2014 2 CLT 511. Cal 511. এটা দাঁড়িয়েছিলেন না?
লিখিত মাত্র আপনার মধ্যে। প্রশ্ন করছি শুনুন
হুম।
নামটা কেন
On the same issue, there is no difference. Why do you need to cite multiple judgments? The question still remains, which we are trying to unravel.
Here, my lord, 198 and
Both these
99
cases,
and along with 70.
both these cases are cases where a person who is not entitled, whether he can get the benefit, he or she can get the benefit of. We are not on that. That's not the issue here.
As also the issue of those who are nominees, they are only
Correct.
entitled to
Correct.
get
So
the,
what are they entitled? That is the issue. The issue is not with that you can ask them to name you as a nominee. That's not the issue here. So both these judgments we are considering. Yes.
But kindly see on page 50 of this book, form to be signed by the employee.
Yes, we have seen that Form
Yes.
A. Form
Yeah.
A.
Annexure 2, Form A.
And there is no dispute that the mother is also a nominee.
Yeah, and what the
Nobody
language
can
is,
deny that she is ineligible or she is
kindly
not.
see, who can sign it? Employee.
We have seen that.
Yeah,
Yes.
and kindly see that other than members of the family, that has been amended in 2005.
Yes.
That has been considered by the
The
decision.
petition 7E. Just make a note, the learned counsel representing respondent number 5 has adopted the submission.
Item number 3.
I beg to appeal on behalf of the petitioner's worship. May I file the appeal? The petitioner is a OBC B category candidate appeared in the written examination for the post of forest guard under the Directorate of Forest, West Bengal in the September 2017. He was declared unsuccessful in the published result.
Which category?
OBC B category.
OBC B.
OBC has two classification,
OBC A and OBC B. He-
most backward and backward.
So which is most? A is most,
Most.
B is most, which is
No, and A is most backward and B is only backward.
so he was BCB.
C.
Yes.
When he found that he is unsuccessful in the result, he has made an application under RTI for knowing his marks.
So this was a recruitment process comprising of written and interview.
Yes, sir, sure.
So he did not, till which stage? He has gone up to the interview stage.
No, Lordship. In the written examination, when he found he is unsuccessful, he made an RTI application for knowing his marks and cutoff marks for the OBC category.
Yes.
He was denied at the first instance, he was denied information under section 8(1)D of the RTI Act. Thereafter, he made a writ petition before the Honorable Court. Then the Honorable Court directed the authorities to give him the information. Then he came to know about his marks and the cutoff marks of all the categories. Then he found that there is a disparity in the cutoff marks of general category and the OBC category. He found that the OBC category cutoff marks is 80.25, whereas the general category cutoff marks is 76.25. Thereafter, he has filed another RTI application seeking
General is 76
76.25.
and OBC is 80.2.
Fine.
Yes, then
Then he made another application seeking information of successful candidate of OBC category entire list. He was again refused under 8(1) subsection 1 of RTI Act. Then he has made another writ petition. He found that the constable male and constable lady Kolkata police also required the same educational qualification as of the forest guard. And there the cutoff marks is very low, that is 22 and 13.75 of OBC category. So there is a very disparity of the cutoff marks. Then he made another application before High Court, and High Court directed him to make an application before the tribunal. Tribunal, he has made 3 points, Lordship. That is the arbitrary conduct of the respondent authorities, disparity of the cutoff marks, and that non-compliance of the Supreme Court guidelines regarding the cutoff marks of the OBC categories. He has stated in the OA application all the decisions of the Supreme Court, but the tribunal has rejected his application on the ground of delay, Lordship. Now, may I place the application order passed by the tribunal, Lordship, which is at page 140, Lordship. After that, I'll place the judgments passed by Supreme Court, Lordship.
Said conceptually what went down.
All
They have
along,
been
he was
condoned.
pursuing the authorities and honorable court, Lordship.
আরে এটা
It
হবে
was
না,
not that
এটা
he
হবে
was
না।
sitting tight over the matter.
তোর বাড়িতে করেছি যাইতে বলছি যাইতে দেরি বলবি টোপাটা বসে বন্ধন করে দাও।
Delay was finally condoned, Lordship.
দেয়নি দিয়ে দেবো
It has not been disposed of on delay.
এই যেটা দিয়েছেন
It has not been disposed of on delay.
No, no. It was disposed of, but without passing any order, Lordship.
So it was not on delay. You said on the delay, it's not on delay. Yes.
But it was not, the points taken by the petitioner has not been
Yes.
considered.
So you said it is arbitrary. Second, you say disparity in cutoff marks between the police recruitment and forest recruitment.
Lordship.
And third is Supreme Court decision. So where is the Supreme Court decision?
In the grounds also, he has.
And before that, what is there in the information which gives you the basis to make such a allegation? What is there in the information which,
Lordship, kindly see page 97, Lordship.
yes.
Here the cutoff marks have been stated. Now, Lordship, may I file the judgments, Lordship?
But you got this information in May 2019. What were you doing for 5 years?
After that, he has made, constantly he has made applications, Lordship. He has, after that,
So making of one representation or after the other is sufficient to
ওটা পোস্ট
delay the matter. In the case of a recruitment process where so many third party rights are concerned.
second paragraph of this judgment, Lordship.
ফাইনাল ফাইনাল after written কত ক্যান্ডিডেট অ্যাপিয়ার করেছে 2-5 মিনিট সবাই অ্যাপয়েন্টমেন্ট হয়ে গেছে এই রিটেন যেটা বলছে রিটেন আপনাদের ফাইনাল এই একটা করে আর কবে দুটো যাবে দুটো না
2011 HSC paragraph 42, last 5 lines, Lordship.
2008 or 20. Mhm. Kada? It is 94.7. It is general. It got a score. It is 97.5. It is general score. It is এটা cut off.
Paragraph.
Paragraph 42, last 5 lines. You see, page 468. It is in context of the cutoff marks of OBC candidates. We therefore pulled the words of maximum cutoff marks. Lordship has found.
Yes, all right.
Present case, the cutoff marks of the applicant petitioner was 71.25 and the cutoff marks of general category 76.25, OBC was 80.25. And Lordship, in page number 103, I have annexed the same education.
You had secured 71.
Yes, Lordship.
Yes.
And I've also annexed the same educational qualification required for constable male and constable female. 103.
No, that we accept it.
Lordship.
Disparity between two different exams cannot be a ground.
So this is only my case.
Yes. Yes, Mr. Mukherjee, how the OBC B cutoff marks is higher than the general? The marks, cutoff marks of OBC B is higher than general.
No, OBC B was 87.5.
No, 80.25. Come to page 97.
No, but according to my profession, last exemption was held. But 87.5, final marks, 87.5, so far as OBC B is concerned, and general candidate 88. 87.05.
And general 88.
General 88.
Then what is this page 97? Who has given this?
It is a written. in a written, and it is a final. Called PST and PT.
Oh, this is and the this is not the final cutoff marks
No, for a final cutoff marks will be selected after interview.
after the interview.
Written is also important because unless and until written is,
First,
how it will get.
first PST physical test.
So if in the written you can prescribe a lower cutoff marks for general
No, that will be decided on the number of applications received.
on the number of
Number of applications received and number of candidates appeared. But then, first PET will be, preliminary PST will be held. Then if they qualified, then they will go to the physical test. Then they are successful. Then the written examination, they are successful. Then we will go to the interview. And 293 post has already been filled up. And so far as cutoff marks of OBC was 87.505 after interview. And it interview.
এগুলো তো এটা পেতে হবে তথ্য শেয়ার সব হাতে দুটো দুটো
This is the chart I have prepared by the board.
no, not required. The question is at the written, are you required to
মার্কসটা পেতে হবে
maintain a lower cutoff for OBC or not?
অফিসে পাস করবে তারপরে
That he obtained 71.25 marks in the written test.
Hmm?
Can you see page 97?
Yes.
Column 1. That he obtained 71.25 marks in the written test.
What?
And OBC B was 80.25.
After police verification, EPSC টেস্ট হবে তারপরে এসে এই কাট অফ মার্কস এখানে
Did you file any opposition in the tribunal?
Today is the first.
You have
No,
approved
at
the
the
tribunal after
first day of admission. It has been disposed of at the date of admission.
can be done. And the recruitment process is specified anywhere,
Yes, and can you see the recruitment?
how the process is to be carried out.
Yes. Can you see the recruitment rules?
এর মধ্যে আছে ওটা একটা পড়ুন কথা বলুন
Advertisement আপনি accept করছো? Advertisement accept করছো? ওই This is the recruitment rules. This is the recruitment rules.
Kindly see page 66.
Okay, rules আছে তো। rules to manage করতে হবে। rules to manage করতে হবে। ভিতরে দিলে কি হবে? আরে rules তো রয়েছে। ভিতরে rules এর পরে advertisement।
Yes, where the rules?
Kindly see rule 3, method of recruitment. Method of and qualification required for recruitment to the post of forest guard under the Directorate of Forest Government of West Bengal shall be as follows. By direct recruitment 2/3, then by promotion 1/3, then male candidates,
Okay.
physical criteria, then the female candidates, then efficiency test, men 25, women 16, then essential qualification,
এই যে দিয়েছে এই
then
physical
physical
fitness
measurement, rule 6, 7,
6 and 7
7, then country,
জায়গাটা উপরে ব্রাথে চলে যান
page
তিন
4,
পাতা।
oh sorry, for the country,
চারটা
page 3, on the basis of the written exemption, short list will be prepared for checking the physical standard followed by physical efficiency test.
দুটো টেস্ট
Finally, on the basis of written exemption, checking of the
ফিজিক্যাল
physical
স্ট্যান্ডার্ড
standard and physical efficiency test, personal test to be conducted. There's no mark for walking test, but the candidate should be qualified in the walking test. The candidate recommended by the surgeon shall have to undergo medical checkup conducted by the chief medical officer. You know, sure, we decide.
ফাইনাল সিলেকশন
Procedure for final selection, candidate who shall satisfy qualify the all conditions of AG as per rule 2 and 3 be considered for final selection on the aggregating of marks obtained in the written exemption and personality test. We have done this.
দ্যাট ইজ দিস চার্ট দ্যাট ইজ চার্টটা কোথায় স্যার এই
And on the basis of this, we have prepared this chart. You do that, you do it.
একই তো বললো আপনাকে বললো নট নেসেসারি রিকোয়ার্ড আরো আছে
So you can give it a look. Done. You give it a look.
Of marks for the written test. 97 shows that it is the written test selection is also based on a cutoff marks.
But three stages of test is there. First, preliminary test, then physical efficiency test and efficiency test, then interview, then final selection. Stage by stage. And
There are two things. One is the cutoff mark, whether it can be fixed the way it has been fixed. But before that, the issue whether when the recruitment process is complete, by the time he has approached the tribunal, because you say the recruitment was complete in 19 itself.
2017,
19 recruitment was completed in
Yes,
19.
2019.
And
Sorry,
she-
2018, 13 February 2018. Final result published on 15 February 2018. And selection board meeting on 13 February 2018.
so even after
এইটা আমি ইনফরমেশন দেখে দেখে এখানে যে ফাইনাল ডেট অফ মার্ক সব এখানে চারটা হবে কি হয়েছে
Male 241 and female 18, total 259 candidates have been required. And all of them joined.
you have not impeded any of the candidates also.
No.
So you have approached the tribunal 6 years after the result, final result. You have not even impeded any of the candidates, and whether it is permissible after 6 years, when you were in possession of this cutoff marks in 19 itself, can the entire recruitment process be upset at the instance of such a person?
For judgment of delay.
Yes, you may.
Custom C. I think Malatot is facing. Custom C is in connection with the.
Information, if he can find out certain things, because
Point is, the information which you are relying upon was with you in 19, that you have
Lordship, may I place page number 25 once, Lordship? Yeah, of the OA application, Lordship. This is part of the OA, Lordship. Page 25, Lordship. Paragraph C, Lordship. The information was received by me after the order passed by Honorable Justice Mantha in 11th of April 2022, Lordship. I received the RTI reply after the order passed by Justice Mantha in 2022, Lordship. Yes, Lordship. That, yes, it is written order. Yes, it is written 2019, Lordship, but that memo has been received by me, Lordship, after I have made a writ petition before the Honorable High Court and after the order passed by the Honorable High Court in 2022, Lordship. After Honorable Justice Mantha has, Lordship, kindly see page 92, Lordship, order passed by Honorable High Court. Page 92.
This is with regard to the appeal under the right to information.
After that, I have received the page 94 RTI reply, Lordship, which is dated 2019, but I have received it after the order passed by Honorable High Court, Lordship. Yes, Lordship, the petitioner is present in court. I have inquired from him. The mistake I have done that the envelope has not been annexed.
Yes, take down. At the very outset, Mr. Mukherjee for the state
Lordship, reply.
Let the opposition be filed within 3 weeks. List.
Item number 4.
This is my app.
Your son, daughter,
I am son,
date of death
2006. My lord, 2000,
as working as
26 December 2006.
working as
my lord, constable,
huh?
constable.
Constable. And when did you make your application?
2000, my lord, 6 itself, 2006, just after the death, 2008 process started. My physical efficiency test was done, interview was done, everything done.
Hmm.
গেজেট আছে 7 ইয়ার্স বাদে আসছে।
রাতেরটা করে রাতেরটা করে
File an opposition there.
No,
You file an opposition. This we want to consider whether the issue that an application has been made on plain paper and not on
Yes.
format.
and after considering all the hurdles,
We'll see.
lots,
File it. 3 weeks, 1 week for reply.
lots. Affidavit of service টা নিয়ে আসি। Sir, affidavit of service। 3 week, 4 এটা,
হবে 3 and 1, right?
3 and চলো ওই যে লিখেছে।
ফাইভ একটু দেখো তো ফাইভ হচ্ছে
Item number 5.
35 তো
My lord, item number 5, my lord. I am for the petitioner led by Mr. Siddhartha Banerjee. Lord, if your lordship kindly comes to the order impugn. My lord, the facts remain, my lord. I have been রেফার করেছে রেফার করেছে 2012 আরে যে মেমোটা ইউপিএল অর্ডারে রেফার হ্যাঁ পেয়েছি নিউ মেমো যেখানে রুল 71 আমি এখানে মিক্স করা আছে কপি আছে কপি আছে জজের কপি 710 আমার একটা চলে এটা হচ্ছে ঠিক আছে লাভ করে My lord, still get the prayer millet at page 90. Milord, the suspension order was annexed. I'm sorry, Milord.
Quashing of suspension order on what ground?
Milord, on the ground of Milord, error of jurisdiction. Milord, on the ground of Milord, its continuation. Milord, for an indefinite period without Milord putting an end to an order of suspension, though Milord, I was
How
placed.
long had it continued when you
Milord,
approached
I
the
was
tribunal?
90 days had lapsed. When Milord,
90 days.
yes, when Milord, the application was moved, 90 days had lapsed, and Milord, we Milord relied upon a decision, Milord, very recent decision of the Honorable Supreme Court.
Where is the CCA? What is the provision in the
Yes.
CCA?
Milord, may I hand up?
That is why we are asking, where is the CCA?
Milord, kindly allow us, Milord, to place the rules.
West Bengal's CCA, where is West Bengal?
CCA rules, such a
CCA rules of West Bengal.
Kindly, Milord, turn to page 13. The page numbers.
Don't have it. Why do you- Page 13.
1-3, Milord, the page numbers are given at the bottom of each page. Oh,
No, where is the provision regarding suspension?
yes, Rule 7, Milord. Rule 7 is at page, Milord, 5, rather 4. May I, Milord, read it out for your lordships?
Reading.
Grateful. Huh.
আমরা জাজমেন্টটা রিলাই করেছিলাম সুপ্রিম কোর্টে সেই জাজমেন্টগুলোর কপি বার করে অজয় কুমার চৌধুরী 2015 ভলিউম 7 তিন কপি বার করে দেন। আর 1994 ভলিউম 4 ভালো বার করে দেন।
So where is the time limit of 90 days in the rule?
Milord, rule is Milord silence on that, silent on that. But Milord, these kinds of rule have been interpreted by the
No,
honorable.
not these kinds of rule. Every rule is distinct in its
Milord,
own reading.
possibly Milord, the rule was perimetria, Milord, subject to my Milord limited
No, we must
understanding.
know that it is perimeteria. We can't proceed on a possibility.
Milord, may I hand up Milord the judgment?
Yes.
No, this is reported at
Plus,
2050.
why are you here when the tribunal has already directed them to have a relook? Then why are you here?
Kindly Milord, just have a look at Milord the review provision. Milord, the tribunal says, Milord, whatever order has been passed is a correct order.
Tribunal
not-
says two things. One is, why have you come without exhausting your remedy?
But the remedy is not available to me here.
There is no appeal against this.
There is an appeal, but Milord, this suspension was actuated by malice.
So
That's-
if
Kind-
everything is in order, why you will go in appeal, sir?
That's true. Milord, kindly just
There has to be something to be raised in appeal.
then tribunal.
You may allege malafide, you may allege many things, extraneous consideration.
True.
But there has to be some infirmity to be raised in appeal.
Milord, I will,
If
Milord,
it is in order, then you will not go in
Milord, I'll
appeal.
try and meet the point of Milord appealability and also Milord the review. Milord, may I
Yes.
take your lordships to the review provisions first?
No,
which
no,
Milord-
where is the appellate provision? Why you
Yes,
have not
Milord, Rule
exhausted
14 is the
appellate
appellate provision. 1(4), Milord.
Then under the Administrative Tribunals Act, how you can maintain an application?
Milord, just kindly have a
How
look
the
at the.
tribunal has passed the order, we are on that for a review. When it is maintainable, only then you can pass an order for review.
Milord, just kindly have a look at the provision of appeal, Milord, Rule 14.
Yes, what is wrong with this?
Now, Milord, it says a government servant who is suspended or is deemed to have been suspended under Rule 7 may prefer an appeal against such suspension to the authority immediately superior to the authority by which he is suspended or is deemed to have been so suspended. Now, Milord, kindly see our suspension order here once, Milord, at page 186.
What is it that you are trying to point out?
Milord, this appellate authority is, Milord, also there in the reviewing authority. Milord, there is a merging of, Milord, the appellate authority with the, Milord, reviewing authority.
Who has suspended you?
Milord, the district magistrate, Milord, has
So the
suspended me.
commissioner will be the next higher
Milord,
authority.
possibly the secretary would be, Milord. Milord, that's what Milord, the state also says.
Secretary.
Secretary. Now, Milord, kindly have a look at the review provision once.
Why should we?
Kindly, Milord, just have a look because I have been shown, Milord, the provision of review by the tribunal
We
below.
are not on that. We are how the tribunal has exercised jurisdiction contrary to the Administrative Tribunals Act without exhausting the remedy.
Milord, once, Milord, the jurisdictional aspect,
Yes.
Milord, I raised, Milord, I say this was not an error in jurisdiction, Milord, this was an error of jurisdiction because I cannot be, Milord, placed under deeming provision of suspension.
We don't know. We are not here looking at the correctness of the suspension.
My Lord is
We
not,
are looking at the issue whether the tribunal was justified in passing any order.
Milord,
When
if
the
the,
Tribunals Act clearly specifies that you are obliged to avail the
but Milord, if
alternative.
the order was without jurisdiction, if there was an
No, no.
error of jurisdiction, then, Milord, the tribunal application would
Suspension
lie.
without jurisdiction.
Milord, I say this because, Milord, they were trying to
Who
invoke.
is the competent person to suspend you?
I'm not on competence, Milord. I am on the mode of exercise of jurisdiction because, Milord, the moment
Irregularity does not mean without
it's not
jurisdiction.
irregularity, Milord.
Even if there is,
Milord, I
we
say,
are not accepting that it is irregular, but
I follow.
unless the jurisdiction is vested, once he is the competent authority, where is the question of lack of
Milord,
jurisdiction?
I tell you, Lordship,
Other infirmities are to be considered in
it's
appeal.
not, Milord, an infirmity, Milord,
other
ministerial infirmity. Milord, I say I cannot be put under suspension under the deeming provision of suspension for an indefinite period. Milord, there has to
Or
be
we are
time.
asking you, where is the time frame?
Milord, kindly
And
just,
if it is without specifying the time frame, you could have gone in appeal.
Milord, kindly once again come back, Milord, to the deeming provision of, Milord, suspension,
Yes.
Rule 7. Kindly,
Yes.
Milord, take it once.
Yes, read it.
কোনটা বলছিস সুদীপ্ত?
এরকম ভাবে তুমি করতে পারবে না।
কোনটা ভাই? সুপ্রিম কোর্ট তো?
না, আমাদের
আচ্ছা। Kindly, Milord, take 7.
We have not found any time specified in Rule 7.
Milord, may I read it out, Milord, for your
Yes,
lordship
you
once
please
for my
specify
satisfaction?
where the
Yes.
time frame is specified.
A government servant who is detained in custody for a period exceeding 18 hours under any law providing for preventive detention or as a result of proceeding either on a criminal charge or otherwise shall be deemed to have been suspended
Yes.
by an order of the appointing authority with effect from the date of his detention and shall remain under suspension until further order.
Yes.
Now, Milord, when Milord this further order should come, Milord, my Lord will kindly get at page 22, Milord 225. Kindly, Milord, take page 225 now. Milord, let us read, Milord, these rules with, Milord, this order issued by, Milord, the Honorable Governor, pursuant to certain directions, Milord, passed by the Honorable Court. Whereas, Milord, this is of 5th of July 2012, the Honorable Court has observed in various departmental service matters that there is no point in keeping an employee under suspension for indefinite period. And whereas the criminal charges do not have official nexus and the employee is not in a position to interfere in the judicial process through misuse of his official position.
Sir,
My case was
we
such.
are not on the issue whether the suspension is legitimately being continued. We are
Milord, I
looking
am
at
on that.
your invocation of the jurisdiction under the Administrative Tribunal
Milord,
Act
this indefinite
without
suspension.
exercising the or availing the remedy provided under the statute. Why the tribunal has exercised jurisdiction? It should not have. There is no scope for directing for review. You have not availed the remedy of appeal.
Milord, after this order, Milord, at page 225, Milord, the authority had lost its jurisdiction to place me under suspension for indefinite period.
We don't find that, sir. We
Milord,
don't
may I
find.
place, Milord, this order once?
Yes, we have read it.
Yes, Milord, page 225,
Yes.
Milord. Kindly, Milord, just take the trouble to just have a look at 225.
Yes.
And whereas there is no scope to initiate disciplinary proceeding against an employee for charges not related to his official
We have
position.
read it, sir. It does not say that henceforward till further orders will stand deleted from Rule 7.
Milord, it's there after that.
Please see.
And whereas the employee is released on bail or against criminal charges, and whereas placement of employee under suspension for indefinite period has an adverse bearing on the livelihood of the family of the employee.
Yes.
And whereas the convicted employee can be dismissed or terminated from service after the criminal case has reached its finality without initiation of DP.
Yes.
Now, after careful consideration of all aspects, sorry, the undersigned is directed by order of the governor to say that the suspension order of peer employees under aforesaid circumstances can be revoked and be allowed to join. The decision on period spent on suspension and consequential benefits will depend on the outcome of the criminal case.
So therefore,
Milord,
again, we are saying there is no curtailment of power or which source lies in Rule 7, which you have read.
for Milord, an indefinite
So
period, Milord,
therefore,
is
you should
curtailed.
have gone in a.
Now, Milord, kindly just have a look at the Supreme Court decision once.
No. Before we go to the decision,
Yes.
show us the rule.
May
That
the rule,
it is in perimeteria.
may the rule is spelled out in the Milord order judgment itself. It's discussed.
Let us see. Tell us first, was there any time frame in that rule? And in that rule, was the tribunal allowed to exercise jurisdiction
Milord,
without
that was not
exhausting
the
the
issue
remedy?
here. That was
We
not
are
the
on
issue
that.
here.
We are not on the duration of the suspension.
Milord, exercise of
not going to
jurisdiction
look
by the
into it.
tribunal is not questioned by anybody. Milord, they have
Sir,
also
you have to satisfy the writ court.
That's
You are
true.
invoking the
That's
writ
true.
court's jurisdiction.
That's true.
So therefore, we are on this. Why did you go to the tribunal? Why without availing the opportunity of appeal? Everything directly tribunal and directly writ court for a suspension matter.
Milord, may I show Milord the review provision then once? Milord, why
Not
Milord
required.
prevented us, Milord, from going to the
Not
appellate?
required.
Milord, if the review committee also consists of Milord the appellate
We
authority.
are not on that. Those issues don't arise here. Because one of the members of the review committee is an appellate authority, therefore you will not avail the opportunity
Then
of
Milord,
appeal.
this appeal is Milord would be an eyewash.
No, sir.
Milord,
It's a far-fetched submission.
Milord, a person, Milord,
It is
who
a
is
far-fetched submission because one of the members of the review committee is the
kindly,
appellate
Milord, have a
authority.
look at the provision of review.
Not. We are
Milord,
not
this is
going
a
to-
government, Milord, it's a statutory review provision.
Sorry. You have not
Kindly, Milord,
assailed the appellate provision.
I
You
have not, but
then this is submissions you cannot make.
kindly will just have a look at the review provision once.
Go in
That is
appeal, you
referred
go
to
in
in the
appeal.
impugned order.
You go in
Kindly will
appeal.
allow me to place that once. I'm sure, my lord, I'll be able, my lord, to
I
convince,
don't
my lord,
think
your
so, sir.
lordship's
The
consent.
tribunal should not have exercised jurisdiction. There is no scope. This
My
is
lord, kindly
contrary
see the
to-
review provision
You
once.
come to rule 20.
Yes, sir.
Yes.
WBCP. Taxation, Administrative Tribunals Act. So, my lord, I'm not carrying the. Thank you.
It has been interpreted by a constitutional bench.
Yes.
Yes, yes, no doubt of that. No doubt of that. No doubt of that, my lord.
And
Section 20, come to, shall not be admitted unless other remedies exhausted. This is a specific mandate.
My lord, I say, my lord, that remedy is
And
not
without
an
exercising
efficacious
the
remedy.
remedy of appeal, the tribunal has entertained the application.
My lord, I
Asked
say,
a direction for review.
my lord,
So the appellate provision has been made redundant altogether.
and tribunal, my lord,
Peculiar
is showing me, my lord, the review
Where is the
provision.
judgment?
1989 Code SSC page 582 paragraph
Yes.
15 and 16. The constitution does that, but it cannot be governed by any other. And this
Full time
section
judgment.
21 has been interpreted.
89.4.582.
SSC page 582. This is rapport versus state of authority, paragraph 15 and 16.
You know, this alternative remedy is possibly not absolute bar
Sir, it
because
is
my lord,
not a case of alternative remedy.
section
The
says
concept of alternative remedy under 226 is not arising here. Here there is a statutory bar
this.
to exercise of jurisdiction by the tribunal without exhausting the alternative remedy.
True.
So
Now, my lord,
that a
section 20
statutory
says, my
remedy
lord,
arises.
tribunal shall not ordinarily, my lord, entertain an
All
application.
right. So this is a
Ordinarily.
very extraordinary
My
circumstance.
lord, my lord, was trying to,
Very
my
well.
lord, place that. My lord, may I just.
20 paragraph 15 and 16.
No. This is a trivial matter. There's nothing.
The section 20 has been the administrative order acting. In period of condition preceded for maintaining itself before that.
Yes, paragraph 20, clear. That is the statutory provision. This is merely a reiteration of the statutory provision. There's nothing new in this.
There's just one thing, my lord, kindly allow me, my lord, to waste my lord's precious time, my lord, for 1 minute by the clock. My lord, just one thing. One thing,
We
my
have
lord.
seen more than enough.
My lord, I am tempted, my lord, to show this. My lord, kindly allow me, my lord, to place just, my lord, once page 234. Just, my lord, just have a look at this. This is one of a kind situation. Just, my lord, kindly have a look at page 234. My lord, just as a student of law, my lord, I was wondering, my lord, in such circumstances, what a person can do. Page 234, kindly see, my lord, kindly skip over the first paragraph. Kindly take paragraph 2. This is a notification by my learned friend's client, my learned senior friend's client, my lord, I'm sorry. After careful consideration of the matter in all its aspects, the governor has been pleased to constitute the following review committee, comprising the following members to review the subsistence allowance granted to the government employees while under suspension, as well as to review the substantive question of suspension. The first person who is the chairman of this committee is the appellate
It is
authority.
not relevant to our query. That is not at all relevant to our query.
Then kindly turn over the page. Kindly see the function of
Enough.
this chairman.
Enough.
Milord, this chairman is to sit, Milord, on regular intervals on the order of
We
suspension.
don't know. All that would have arisen had you availed any remedy. You have not done anything.
Now, Milord, this
Straight away
gentleman,
come
Milord,
to
will
the
be
tribunal,
wearing, Milord,
tribunal
two
has-
hats.
Sorry,
Milord, he'll be wearing two hats, one
we
as an
don't know.
appellate
Yes,
authority.
come.
May I, Milord, then make a humble prayer.
Those
My
issues
Lord,
don't arise, we are not going to consider those issues. We
Then
are
my-
only on the statutory bar under Rule 20.
late submission was respondent number 8 would not be, Milord, the authority. Milord, late, Milord, my learned senior friend indicate, Milord, who would be the appellate
Sir, it
authority.
is the rule which neither he can say nor you can say.
So then, my Lord, Milord, kindly not say, Milord, respondent number 8, Milord, the appropriate authority.
Don't say respond number 8, appellate authority.
Grateful, Milord, grateful. Sorry, Milord, I troubled your lordships, Milord. It's our duty, Milord, to
Yes.
try. Yeah.
We know.
And most of them have same experience.
When I felt that when I was annoying your lordships.
Item number 6.
Additional two. আমাদের পরেরটা না 6 এটাই 6 তো গাড়ি কি বলছে গাড়িতে আছে লিফট আছে এটা বাবু আছে ঠিক আছে এই করে স্টেট কে পার্টি করতেই হবে এই যে বলে দিচ্ছি অ্যাপ্লিকেশনটা আছে হচ্ছে ফার্স্ট অ্যাপ্লিকেশন দেখ 17 সালে না মানে এটা বলছি ওই এটা ওইটাতে কোনো দেয় স্টেট কে পার্টি বাকি এক নম্বর ট্রান্সলেশন হয় 17 সালে যেটা বলছেন দ্যাটস অন 19/2 এ মারা গেছে 19/2 ষোলোতে সার্টিফিকেট কপিটা দেখাচ্ছি
Yes.
তাহলে পুলিশ স্টেট অফ ওয়েস্ট বেঙ্গল
Yes.
Well, I am for the petitioner. Miller, there are two
Responded.
defects. No, Miller, there are two defects. First of all, Miller, the state is a necessary party, but the state was not implemented, Miller, in the original application, and
In
as
the
such,
OA,
way.
37
State
37.
Administrative Tribunal without implementing.
Oh,
the
yes,
state.
yes, Miller, that is exactly, and Miller, that is why we could not. When I seek leave from my lords, Miller, to incorporate the state of West Bengal appropriate department, Miller, and to serve upon Miller the government
But
leaders.
if they were not party there, then how they can be a party here?
Miller, this is an original proceeding, Miller, the fast court, Miller, but Miller, the court did not take into an account, Miller, this fact. Court said, Miller, in a compassionate appointment, the death occurred, Miller, in 1912-2016.
Where is the OA?
37.
Page 37.
Yes, my lord. All the respondents individual, but not the state of West Bengal. It should be, Miller, represented by state of West Bengal, but that is nomenclature is absent.
we have served all the
And we have served, Miller, all those
all the
respondents.
respondents in the area of party
Why your counterpart is not appearing? Mr. Mukherjee was
Because
just here.
the office of the government pleader, which I required to serve, Miller, they could not accept, Miller, because of this fact.
the state of West Bengal
So, Miller, I seek, Miller, an amendment, Miller, of the cost title sick leave, and I will do it here and now.
And there the state council appeared.
There, yes, name is, Miller. Yes, Mr. D. Cole for the state respondents. In the impugned order, Miller, 11/12/2024.
and the court title appears to
So
be-
And
here
the
also
cost-
the issue is whether application is required to submit it on format or not.
Right.
See, we have just, I think, one or two matters before this, we have asked Mr. Mukherjee to address us on this issue because we want to resolve this, whether they can insist that application has to be submitted on format or the time will stop running the moment a plain application form is submitted. Of course, the format is required subsequently to assess the claim, entitlement
You
of
can
the claim
rectify this error.
with reference to the parameters
Right,
specified in
right.
the form. But whether the time will get arrested on submission of a plain paper application or not, we have asked him to assist in one case. So
But your lordships have been pleased to fix that case on the next week,
after 4 weeks.
4 weeks. So Milord, this matter may be kindly.
Therefore, we are saying with if this can come with the other.
All right, I will get the information. I will supply to your lordships.
Right. Probably 4.
Doctor, 3 and 4, Milord.
No, there was only one case. Not 2 cases. There was one case. Because in one case we have gone through the provisions, it does mandate that a format is required to be submitted, and without submission of format, it is not possible to assess the entitlement under the scheme. But that time frame has to prima facie whether it can continue to run even after the application, because there is some provision which says that they are to assist also for availing the benefit of compassionate appointment.
Yes, that is true. But Milord, here admittedly, Milord, 2016, 19 February, death occurred. 2017, mother and son, Milord, applied.
On plain paper.
Yes, plain paper. And thereafter then, 2021 December, they asked me to appear before the inquiry authority, before the inquiry board, and asked me to submit the format. We did it so, Milord. 2022, 2023, Milord, the rejection came that is since it was not in format. Now, Milord, this is the question. So, Milord, let my learned senior friend, Milord, address this issue. Whether, Milord, if there is a time frame, initially it was for a period of 6 months, then it was extended within a period of 2 years. There are 2 aspects, Milord. Because even if I survive on this, Milord, if your lordships are with us, Milord, with regard to the technicalities, it is required. But whether it is so grave a mistake that cannot be rectified, if that is not the views of this honorable bench, Milord, even if I survive on the first hurdle, then, Milord, the next hurdle that might come, Milord, that my family income, my mother, Milord, on account of her family pension and death gratuity benefit, all these things, the income that has achieved, if it exceeds
90%.
If it exceeds, Milord, the gratuity, then, Milord, I cannot be considered, because the government takes a very popular plea, Milord, in the Curial combat. The time goes, compassion goes, Milord.
Right, but the time goes, there are both kinds of decisions
Yes.
you must be knowing. Just
Yes.
because a person has managed to survive, therefore,
Yes,
there is a line of judgments on that.
yes,
The other is that because he has survived, therefore.
yes, yes.
So it
But the
will-
question is, Milord, whether it's a mere animal existence in terms of the present consumer,
So that has been considered by the.
as your lordship. 5 নম্বরটা শুরু করেন।
Is he
Milord,
coming?
may I take my lords kindly?
Yes.
I will note and leave to correct the cost title and incorporate the state of West Bengal as a particular.
Comes for the.
And also, Milord, allow me to submit, Milord, translation of the Bengali representative. I have to submit, Milord.
Counsel
May I
for
take
the
my lords
petitioner
kindly,
is
ma'am?
permitted.
I shall provide the number to your lordship.
Item number 7.
Please, my lords, Milord. এদিকে।
My lord, I am appearing on behalf of the respondent. My lord, my senior counsel could not present today due to his personal difficulties. My lord, I am praying for adjourn the case today.
Appeal by Union of India.
Yes, Milord, the tribunal has allowed the original application Not for grant of blood, certain he was blood discharge, blood on being,
Some difficulty.
if they don't blood press for the relief or put it for blood contempt, I don't mind blood.
There is a contempt pending.
No, they have not filed yet. Contempt file করেনি তো? If they say they will not file blood, I have no issues blood whenever they want to come back.
File, then nothing will happen immediately. Let it come in the next week.
But I don't oppose at all.
Straight by the learned counsel for the respondent. Yes. Retain its position. Yes.
Item number 8.
On a plain paper or format. Which matter was that today?
Just give me 1 second. Give me for this. Format is here.
Today we have fixed, we have adjourned a matter in which that issue is arising.
And another issue is there. I think there, let's say, 2020 Volume 7 SSC, NC Santos versus Union of India. Their lordship held 3 judges bench that on the date of consideration of the applications.
No,
Another-
that is a different thing. Today, one matter we have taken up, we have fixed it after 4 weeks. Where the issue which arises is whether application is required to be submitted on
In the
format.
prescribed format.
Which is that matter which we have fixed for 4 weeks? Do you remember?
Just,
Number 3 or 4 something. Today we have done it. In
no,
today's.
today we are till now they haven't been taken.
Yes, today we have done. In one case.
Just I will check up on it.
Yes.
But that rule, that annexer was not there in the format. I have handed over a compilation. That format was not there.
It's not there in the format.
Format I'm
Give it. You have one copy.
just after one side.
Yes.
My lord, item number 8, my lord, same prayer, my lord.
Item number 8.
My lord, I am for the appellant.
I am for the respondent.
Same.
Same prayer, my lord.
All right. 1 week.
My lord, I am filing a affidavit of service, lord.
Hmm?
Affidavit of service, my lord.
Yes. Affidavit of service taken on record.
I'm great.
Wait, my lord.
Item number 9.
Item number 9, Mr. Item number 9, Mr. Ashim Kumar Nagiri is appearing in behalf of the petitioner. Is suffering from illness. So kindly note today. 9.
4. You make a note. Tell us when it is taken up after a week.
Shall I mention when that matter is taken up?
When it comes after a week, inform us so it can be listed with that. In the meantime, you do whatever is required. Not today,
Item number 9, my lord. I am for the respondent, my lord.
not today, yes.
My lord, if you can be done Friday, my lord, but tomorrow.
Let him, tomorrow he will say, then we will see what.
Yes.
You are for
Respondent, my lord.
respondent means?
My lord, Union of India.
All right, in presence of learned counsel for the respondent,
For the
matters,
respondent.
matter stands adjourned for the day.
Number DC. Oh.
Item number 10.
Please, Your Lordship. Matters relate to land loser, my lord.
Did not qualify in the physical efficiency test.
Oh, that, yes. Here, no, the tribunal dismissed. We are before your lordship. Earlier orders were passed. That order was followed by the learned tribunal. The order of the learned tribunal was set aside and quashed by this honorable court.
We are asking you, you have not been granted by assigning a reason, did not qualify in the physical efficiency.
Matter was pending there, my lord. And in the contempt rule was issued. Contempt was dropped. We came before this. We are before this honorable court. Those were the reasons. Those were the reasons. But here, my lord, this is settled now by the orders passed by your lordship sitting with my lord Justice Tandon had passed there.
Therefore, we are asking you ultimately, what is the reason?
They had dropped the contempt.
Yes.
Not complying with the order, that was dropped. The contempt was dropped pursuant to an order passed by the tribunal in the other set of matters. If you do the service. If you do the service. Page 42, the order is the relevant portion of the order.
The contempt has been dropped on which compliance report?
My lord, the compliance report that we are doing, we are processing the case. That was the.
So they have not said that you are not entitled. They are
No.
only saying that we are processing.
We are processing the case. And the contempt was dropped. Although the original order of 16/7/2023, that order.
So when they are processing, then why are you agreed?
No, because my lord, that order was challenged before this court, and this court said no question of dropping of the contempt. You proceed and complete the process within a certain time frame, and you cannot take the points which you are.
So in the
same order is required to be passed by my lord.
In their compliance report, they have not specified any time frame.
No.
Where is the compliance?
Lord, I don't think that was annexed here, but the statement is here. Lordship will kindly. my lord, kindly comes to page 40, my lord, of the order. Last page. Inner page 40 of the order.
Page 40 of the order.
Yes, my lord. At the top, the number is there. The page number. Last page. The impugned order, my lord.
Impugned order.
Paragraph, final order, paragraph
Order.
27.
Impugned order is
The second volume, probably.
where is the compliance report, sir? We are asking you, why are you showing us the judgment?
No, because
Where you said it has been noted in the order, where is that compliance report?
my lord, I don't think the compliance report.
That is the basis of the CAT's order and it is not
Lordship.
here.
No, because my lord, why I'm telling you, lordship?
Please show us the orders.
Lordship. Annexure P18, my lord.
Page, please.
Lordship. Two 230, my lord. Starts at page 234 after the cause title. Take it.
Where have they said that it is in process?
My lord, page 240, inner page 11 of the.
Yes.
First of all, my lord, the age relaxation of 15 years has been given as per Honorable Supreme Court in Shankar Prasad Deep. This was a totally different case that the tribunal has held earlier. Then, my lord, in terms of paragraph 9,
Yes. Where does it say that it is in the process?
No, my lord.
You said that they have stated before the.
No, that's
tribunal
what
that-
they stated before at the time of argument, my lord. That is what was stated and that was what was recorded.
Where is it recorded? The impugned order also does not record any such statement.
Yes, my lord. Just give me a minute. My lord, kindly comes to
Can you tell us where the order passed in
page 242, the last stand that they have taken, my lord. Page 242. Paragraph 12. Roman 12.
No, they don't say that it is in the.
No, it objects this way, and then, my lord, the tribunal, how it drops the contempt. Lordship will kindly come to that. Page 43 of the order of the learned tribunal, my lord. Thus, it cannot be said after two lines.
13/6/2023.
Yes,
The contempt has been dropped.
yes.
The order is a one-page order.
No. Yes, on the basis of the earlier order passed by the tribunal.
CP 187 of 2000.
Yes, the other orders, my lord, that
Where is CP 186 of 2000?
That order is here, my lord.
187 of 2016.
মোটা তো মোটা অসুবিধা হচ্ছে ঠিক আছে দেখছি Hmm.
259.
Hmm.
This particular case.
Hmm.
Which I was in this matter.
Below 359A, the order of the tribunal.
Where is the order passed in CP 187 of 2016?
Yes, CP18 is at page. Page 317. Lord. Yeah, what is it? Order dated 18/4/2023 at page 317.
Annexure P19.
Annexure P19. It's a quite long order.
Yes, the respondents are continuing the processing of the case
Yes.
for grant of employment. So how much time you will take, sir? Your stand is recorded by the tribunal. Give us a time.
I find that similar matters are pending before your lordship from item number 37 to 40 in today's list. This matter may be tagged together so that
So you tell us
No,
a
no,
time frame.
that
in
is
this.
a different matter.
same thing.
You tell us a time frame. You tell us a time frame. Because your stand is recorded that you are complying with the order.
Yes, we are not sitting idle.
And this order has been set aside.
Therefore, how long we will take? This order is of which date? CP 187 is of
Milord, 18/4/2023.
quite a long time.
But kindly keep it after 2 weeks, Lord.
Yes.
Let me take.
Third Lord Counsel for the petition.
Item number 11. Sorry. Item number 101.
See, that matter is being uploaded maybe today or by tomorrow. it will- So let it come in the next week.
As your lordships. As your.
Both parties are in appearance.
It's at 2 p.m. Hello, at 2 p.m.
2 p.m. Yes, 2 p.m.
I'm grateful. Sombar 2.
Number 2 be. Check. এটাই তো হলো 101 এটা বিশ্বাস এগুলো এটা সোমবার 197 আছে 97 98 আছে
11.
11 নরমাল লিস্ট দিন এটাকে স্টেপল করে দিন তাই তো সেল তো আলাদা করে বড় সি মানে দুর্গাপুর স্টিল স্টিল অথরিটি এবং দুর্গাপুর স্টিল তাই তো করে দিচ্ছিলাম
None appears for the petitioner. He's saying application was undated. How you process?
Item number 12.
Milord, I shall be opposing the application with Mr. Lokipal. Milord, your lordship kindly give me certain time.
You are for?
Respondent
We are for the restaurant number 2, 3, and 5.
2, 3, and 5.
Where is the petitioner? Oh,
Time check on
none appears for the petitioner.
My lord, kindly give me another more time, my lord.
Let him come, we'll see.
Item number 13.
May it please your lordship. Lordship, this. একটা কোথায় স্টে আছে বিজনেস বিজনেস উপরে দেওয়া আছে সিনপসিসের পরিবেশের এখানে দেওয়া আছে May it please your lordship. Lordship, Lordship, the respondent, I mean, by an order of transfer, a large number of officers were transferred throughout the country. The
A chain transfer.
chain transfer. It was and he was transferred from Kolkata to Bengaluru, Lordship.
Kolkata to?
Bengaluru. Now, he's a senior accounts officer where transferred is an incidence of service. He was in this station in Kolkata for 6 years, 6 months. Now this, and prior to the transfer, and when the transfers were being contemplated, we had given them the option to give places of preference. Lordship will just see it. He just said Kolkata and others not applicable. I'll just
So he did not give any other choice.
he did not give any other choice.
Yes.
But he had in, but Lordship, that comes to page 104, the format that was to be filled in by the station seniors. And Lordship sees first preference Kolkata. He is in Kolkata for 6.5 years. Second preference, Lordship, page 104, the format to be filled in. When we had given them the officers were informed that their the transfer policy was to be passed, and I mean the orders of transfer, and they were
So in effect, he is seeking exemption from the transfer itself.
yes, Lordship. He on the plea of his spouse, Lordship. She's a teacher in a government-aided school, and that is the only plea that he's taken. In any case, he is not given any option.
Let
Now,
us see the order.
Lordship. Lordship, the order, Lordship. Lordship. Lordship,
So you have allowed him to resume his duty?
no, Lordship, we have not allowed him to resume his duty
Why
after
have you
being.
not complied with
Lordship, we have challenged that order, Lordship, that
Yes.
we've come before your Lordship for that reason, Lordship, and now there's a contempt which is also fixed on the 17th of March. Lordship, why that is, we've come before your Lordships challenging the order, and therefore we have not allowed it.
There is a contempt.
Yes, Lordship, and that is fixed on the 17th of March.
What is the number?
Lordship, the number, content number. Lordship, Lordship, the number is CP 36 of 2025, arising out of OA 106 of 2025. Lordship, I've yes, Lordship, affidavit of services there. This is the and এটাই 17 তারিখে ফিক্স হয়েছে তো Lordship, if you're returning Lordship, these are the cause lists for Lordship, these are the cause lists of the CAT of the 28th and আমাদের তো এটা affirmed হলো কবে?
Yes, give it.
Lordship, the cause list, that is the cause list of 28th February, where the contempt was listed. Lordship, this application was affirmed earlier, the application before your Lordships, and this contempt has been listed on the returnable date, 17th of March. So, therefore, Lordship, I'm just praying for a protection on.
Just now it is just listed. What?
Yes, but
Let's see what happens. Let him appear.
but then Lordship, but still Lordships would just grant a protection because, I mean,
You were heard before the tribunal, before passing of this order.
yes, we had given the submissions, we had given all the details, but produced the document that it was authored, the document, it was authorized by the Controller General of Defense Accounts. Everything was being given, but anyway, the tribunal took the view that since the CGDA was directed to do it, to dispose of the representation, therefore, Lordship, but Lordship, he has been released already, Lordship.
He's working in your office. Why don't you give him a notice?
He knows about this. He sent a mail. He's fully aware, Lordship.
Maybe,
But I understand. But maybe Lordship knows. I mean, it's best not to be here today, Lordship.
Affidavit of service taken.
Deeply applied.
Item number
Yeah,
14.
I'm बोले. Lord, in this matter, Lord, in this matter, Lord, I appear for the Union of India, Southeastern Railway. Thing is this, Lord, before I proceed with the matter, Lord, I should bring to your Lordship's kind notice that the impugned order has been passed by the administrative member sitting singly. Review judgment is awaited.
Yes. Ask the same order. You have that order.
Two weeks or 3 weeks? Lord? 3 weeks. Lord, only one order, if your Lordship records, Lord, they should not proceed with the contempt. Lord. The respondent, we have served.
What is the number of the contempt?
Contempt, I do not know whether it has been filed, but it might have been
If
filed.
that occasion arises, then you.
All right. I'm grateful.
Item number 15.
Lordship, I am appearing for the petition. Lordship. Lordship, petitioner herein had participated in a selection process initiated by the Border Roads Organization for the post of driver static engineer. Advertisement was published on 31st of May 2007. He was applied for, if your Lordship kindly come to page 43 of my petition, driver engine static, post number, serial number 22. Advertisement starts from page 42 of my writ application. Post number 22, driver engine static. Petitioner have applied for that. It is a multi-tier selection process, Lordship. He was initially, his candidature was accepted. His educational qualification was verified. Thereafter, yes, Lordship. Lordship, I tell you, Lordship, I have some point. But Lordship, kindly come to impugned order. Lordship, kindly come to impugned order without calling for affidavits. Without calling for affidavits, I have an innocuous prayer before the tribunal that my detailed medical examination is pending. That was not done. I was called for the second time.
Order is of 2018.
Yes, Lordship.
Very nice. And what is
Lordship,
the point in this?
Lordship, I have no explanation to that
What is
effect.
this?
But
The present case arises.
Much obliged.
এটা একটু আমার একটা কল করুন, কল করে কল করুন, কল
Item number 16.
My lord, item number 16, I am appearing on behalf of the petitioner, my lord. I am led by my senior Dijodas Mukherjee, my lord. If your lordship kindly take up the matter tomorrow, my lord, day after tomorrow, my lord.
Not today.
Grateful, my lord.
My lord, I have a only humble submission.
Not
that these respondents are covered by judgment of Honorable Apex Court as well as judgment of this bench, Honorable
Call the
this
next
bench of this court as well.
Call the next.
20 days back only, my lord has heard. Sir,
When he is not today, why are you pushing that?
Okay.
This is the way. When it is not today, then we should see the
No,
judgment.
I couldn't heard that, sir. My apologies. My lord, I am appearing, my lord, for the petitioner, my lord. Here, petitioner is the first time, my lord, before lordship, the Air Force, my lord. Earlier, in all other matters, my lord, Army was the petitioner, my lord.
So now Air Force has also come.
Yes, my lord.
By virtue of my learned friend, my lord.
Yes. Which issue is this?
My lord, I'm before going to the impugned order, my lord, I want to read some provision of AFT Act, my lord. Yeah.
আমাদের সত্যি নেই, আমার কাছে পেনশন রেগুলার আছে।
Yes.
My lord, section 14, subsection 5, my lord.
Yes.
The tribunal shall decide both the questions of law and facts that may be raised before it.
Yes.
Now, your lordship, I am inviting your lordship attention. Kindly see section 22 in respect of the limitations. Relevant para, my lord, subpara 2, my lord. C, sorry, my lord, C. Subpara C of section. In case where the grievances in respect of which an application is made had arisen by the reason of any order made at the time of during the period of 3 years, immediately preceding the date on which the jurisdiction powers and authority of the tribunal became exercisable under this act. Act come before your my lord, in 2007, my lord.
Yes. So
after 3 years, within 3 years from the enforcement of the act, he can approach before the honorable tribunal, my lord.
No.
In case where the grievance in respect of which an application is made had arisen by reason of any order made at any time during the period of 3 years, immediately preceding
that means prior to coming into force of the act.
prior to the coming into the
Yes, not after, prior to coming into force of
thereafter, my lord, subsection 2, my lord. Notwithstanding anything contained in subsection 1, the tribunal may admit an application after a period of 6 months referred to in clause A or clause B of section 1, as the case may be, or prior to the period of 3 years specified in clause C. If the tribunal is satisfied that the applicant had sufficient cause for not making the application within such period. In the instant case, my lord, respondent was enrolled in the year 1983.
ওডি চলছে
Where does it say? It says, shall not, in the case where the grievance in respect to this is made by reason of the wherever the certificate, it has been commenced before the hearing. This government shall not when in a case where the grievance in respect to which the period of immediately preceding the date on which the course of the act in respect of the matter which shall not and if proceedings for redressal of had been commenced, they are not then it shall not be yeah, he is not happened. As it is. Yeah. Tribunal is satisfied that the decision was not receiving the so very yes. If they have not education is like last 3 years, where I was in the course, but they are able to satisfy for sufficient right? Yes. Say that
Yes. My lord, in the instant case, my lord, respondent was enrolled as an electrical technician on 7th March 1983, and he was discharged on 1st November 1985. Total service was, my lord, 2 years and 240 days.
So what is the relief that he is claiming?
My lord, I am kindly see, my lord.
He was discharged in 85.
85.
And after that, he has remained discharged.
Discharged, my lord. And all the documents, medical board proceeding, all have been destroyed, my lord, as per rule, my lord. Kindly see.
After discharge, there is no appeal, no review.
No,
nothing.
no.
So after 1/11/85, after his discharge, nothing.
Nothing.
Then he approached the tribunal.
Tribunal.
For what relief?
After 35 years, my lord, kindly see page 42.
What is the relief that he was?
Disability pension. Prayer of the respondent
Page
was
42.
42, my lord. Prayer be, my lord. To pass an appropriate order directing the concerned respondent authority and each one of them to grant disability pension.
So he filed an appeal in 2013.
But no proof, my lord. We have
That is what he is claiming.
Claiming.
And what the tribunal has done?
Tribunal, instead of passing the order of disability pension, passed the order of invalid pension, my lord. Kindly see, my lord. Page 182, my lord. For the para 20, my lord. Respondent case was, my lord, for disability pension. And Honorable Tribunal passed the order in respect of invalid pension.
Yes, what do you have
Thereafter,
to
my lord,
say about invalid pension?
my lord,
Why he should not get the invalid pension?
my lord, I'm submitting, my lord.
Come to rule 197.
Now, before that, my lord, I would like to invite, my lord, para 8, page 5, my lord, of my writ petition. 8. Respondent have full knowledge that after the lapse of 35 years, records have been destroyed. Thereafter, they approach, my lord. Para 8, my lord, the petitioner humbly state that as per row 15 and 24, read with section 6, paragraph number 1026 of chapter 18, correspondence, records and reports of the defense service regulations, the medical records of defense persons are retained for a period of maximum 25 years. The rules are given below, my lord. We have stated the relevant rules, my lord. After 25 years, all the documents have been destroyed. If your lordship direct me to produce the medical record, we cannot produce, my lord.
What is required for invalid pension?
Yeah, I'm
Beyond annexure P1, what
P1,
is
my lord.
required? Come to page
minimum
20.
10 years service, my lord.
Come to page 24.
24. This is my long roll, my lord.
This is
long roll. Only this document, my lord, lying with us, my lord.
So beyond this, what is required? He was discharged as being
Medically unfit.
medically low category.
Low category.
Low medical category.
Low medical category.
Now, apart from that, what is
Whether
required?
there is some casual connection with the Air Force service or not.
So where is that required? Casual connection? Where is
At
that required?
medical board proceeding, my lord.
Where is the requirement under the rule that it has to be in connection with casual connection?
For giving the benefit of disability pension, my lord.
Which rule says so?
Yes, my lord. 157. Kindly see
197.
page 110, my lord.
197 or 150?
No, 110 page.
Yes. 110. Yes, we have it.
Rule 153.
Yes.
Unless otherwise specifically provided, a disability pension may be
We are
granted.
not on disability pension. We are asking you about invalid pension.
I'm giving.
Invalid is 197. Therefore, we are asking you to see 197. There is no such requirement of casual connection. And it is a very small amount also. Some kind of assistance maybe is 153 is regarding disability pension.
My lord, kindly see page 119, my lord.
Yes.
Provision for invalid pension to armed forces personnel before the completion of 10 years of qualifying service. Government of India, Ministry of Personnel, Public Grievances and Pensions, Department of Pension and Pensioners Welfare.
That you have already decided that even if it is less than 10 years, we will give it. This is the decision that even if it is less than 10 years, we will give it.
My lord, suppose if he is entitled, before entitlement, we should consider whether the disability is any casual connection with the Air Force.
Where is the requirement of casual connection unless you show why you should consider, sir? Which rule says that for disability pension, he has to show that there is a casual connection? Where is rule 197? Show us rule 197. Rule 197 has been quoted in the FT's order. Come to page 6. 197C. There is no such requirement. You should have given it to him on your own. Unless you can show that there is any other rule coming in the way. You are not showing any rule. If 197C, then he is entitled.
My lord, learned honorable tribunal also relying rule, kindly see page 2 of the impugned order, para 5.
No, it is only relying on 197C. Don't take us here and there unnecessarily.
An individual who is invalid out of service on account of a disability which is neither attributable nor aggravated by service. An individual who is through invalid out of service on account of disability which is attributable to aggravated service, but the disability assessed for lack of alternative employment.
Everybody has to get it. And this decision you have taken that even prior to 2020, all those cases we will give.
No, my lord, this is the rules. Here the rules are different, my lord. They are also relying rules.
We are repeatedly asking you, sir, show us which rule is coming in the way. Show us.
171.
You show us today. If you don't have it, we are willing to grant you one time. But show us.
Day after. Very well, my lord. Day after tomorrow, my lord.
All right. In presence of learned counsel for the respondent.
Item number 18.
Well, I am respondent applicant.
After 16th November. My lord, in this matter, it's my appeal, my lord, but I am praying times if it can be taken up after 16th, because my lord, similar matters have been taken up by Honorable Justice Tarboda Chakraborty. They are interim stay, my lord. I have to collect that all those.
My lord, my humble submissions, my lord. What my learned friend is relying upon the judgment, lord, that is totally different matter, my lord.
Same,
If your lordship kindly,
same,
my lord,
same
lordship
disability
for
pension.
granting a time, lordship, I am not standing on his way, but the way.
As prayed, matter be.
It will be on behalf of respondent. I am led by Mr.
I am for the respondent one. An MA application was made, my lord, to recall the original order. That was rejected. Original order was that since the matter stands infructuous, so therefore let the OA be dismissed. That was the final order. For its recalling, my lord, they made an application, and thereupon this order was passed on 13th of March 2024. I am for the respondent, although. None appears on behalf of the petitioner.
I beg apology, my lord, for being late, my lord.
What do you want?
My lord, have a day accommodation, my lord.
Not today.
I'm grateful, my lord. I beg apology.
Item number 20.
Application for restoration. Old one, Milord. About Milord, the subject matter of challenge, Milord, the petitioner was the female warder in the jail, correctional. He was selected through process of selection. He was allowed to join and rendered some service, but some pay was not granted to him. The court direction was issued to pay the pay. And that was not granted, Milord. Even then, Milord, the appointment letter was not issued. Then, Milord, that part was not considered. Then we approached before the Honorable High Court. That is the order of the court. Direction, the authority, Milord, your Lordship, kindly starts from the page 28, 2013. Order is there.
Participated in the recruitment process for female
Yes.
warder. She was not selected.
No, he was selected. Name was sponsored by the Employment Exchange.
All right, then.
I took part in the
No,
process of
sponsored
selection.
by employment exchange does not mean selected.
No, he was sponsored by the Employment Exchange. I took part in the process of selection.
All right, then.
Through process of selection, PET, physical efficiency test and the measurement test, PMT, all over there. Viva was there. I was selected. But very unfortunately, I have rendered the service to the such post, the female warder. But payment for that post, other person was
You have rendered the service for how long?
No, only he was appointed on 9th January 2009 and discharged on 1st April 2009.
discharge with, if it is discharge, there is no question, no issue was issued, order of discharge was issued.
When you were discharged?
Then we have rendered the service.
1st April
2009.
Not allowed to work, no question of discharge.
Only for 3 months.
Sorry. I am not discharged. I was not allowed to render the service.
After April.
Yes.
After April, you were not allowed to work.
What?
Without any order. That is your case.
Yes.
Then what did you do?
Then, your Lordship, if we go to the coordinate bench directed to issue the order directing the concerned authority to produce the all relevant document that is there. Your Lordship will.
This proceeding.
Yes. This proceeding. Your Lordship, kindly see.
No. First, tell us what is your case. We'll see.
My case, Milord, I was discriminated. Some persons were appointed, they are paid the salary, but my case was not considered.
How do you say not considered? Yourself, you have said that on 9/1/2009 you were appointed as female warder. So, did you get any salary? Did you not get any salary? What is your case?
Without assigning any reason, Milord.
You have been been prevented from working since April 2009.
Yes.
What did you do after that?
Thereafter, Milord, no payment was, no appointment was granted, but he was not allowed to work. That's why, Milord.
How many times we have in January appointed, after April not allowed to work. So what did you do after April? That we are asking.
Thereafter, my lord, we made representation before the authority concerned to allow them
To work
pay.
and to make the payment.
Yes, but that was not considered. Then we approached before the tribunal. The tribunal directed also there.
What the tribunal direct?
Yes, the order of the tribunal, your lordship, is the order.
Let us see.
Dated. হ্যাঁ, ওর মধ্যে annex করা আছে। But I have collected the transfer deed, your lordship, from there 16/9/2009. OA number 936, your lordship,
16/9/2009, yes.
your lordship, second paragraph, second page. Last second page, last but 2 or 3 lines. Authority was not correct in issuing the appointment letter, and they are not sought matter of with the higher authority. We, however, make it clear that once petition have been engaged and they have provided the service for certain period. Next page. Whether there is no any indication regarding the source of payment of salary, authority is duty bound to pay their salary for as promised to them by the appointment letter. Hence, we direct the superintendent of correctional to take matter with the appropriate authority to make payment for period for which the petitioner renders service and remaining payer Miller. The authority is to take matter with the appropriate authority to decide the issue. The salary for petitioner must be paid within the period of paid within 2 months from the communication of this application and disposed of. Number paragraph. 30
So you have not been paid for these 4 months.
Then we approach paragraph 29 of my writ application, you will find why we approach. Then, Milord, the order of the coordinate bench of this court, Milord, you will also find several order has been passed. Page you will also find from the.
Where is the advertisement pursuant to which you were appointed? Where is the advertisement pursuant to which you were appointed?
No advertisement.
Let him.
My restaurant. আমি চেষ্টা করি আমি পুরনো গ্রিপ তো
Where is the appointment letter?
Appointment ইয়েটা দেন না লিস্টটা এবং ডেটটা appointment letter মিলা appointment letter তো কোথায় আছে ইস্যু অ্যারেঞ্জমেন্টটা বলছে Your lordship will kindly see the 12/7 Your lordship kindly before that advertisement আছে okay 52 Yes, I am trying. What advertisement to put? Appointment. Advertisement to which? Page 50 below your In this case, my lord, no advertisement was there. Name was sponsored by the employment exchange. Page 50. Your lordship.
The nature of appointment is,
Your lordship,
you are not disputing, you are not disputing the nature of appointment.
But your lordship, what the order passed, several order passed by the coordinated bench.
There is a question of any proceeding of such an employee. There is no question of any proceeding. Extra temporary female warder without any sanction. Some superintendent takes name from the employment exchange. He appoints some persons. What is the right of such person?
Right, my lord, your lordship, some other person, those who are below to the name of the petitioner, they have been allowed to join and they are working. Why their appointment, your lordship, for a moment?
They are not before the tribunal, they are not before us.
Your lordship, is the order of this
of the
coordinated bench. Your lordship,
No,
several direction was issued by the
maybe-
IG, direction to produce the appointment.
His direction since 15 years.
But your lordship, hearing of this matter, adjourn the such and such corrections is directed to appear before the court in person.
Not
With
required. We don't
with
require.
In order to assist the court.
We don't require. Today, Mr. Mukherjee is appearing. Where is your appointment order? Show us. You can't ask them to make out your case. You have to make out your case.
Your lordship, page 55. In another case, I am producing another.
How many are there petitioners?
Page 55.
Four petitioners.
Four.
Four petition. 55. এর সঙ্গে মিলছে না দেখি order number.
So this is the similar order for all the persons.
All.
Page 56.
Page 55 of the one, 65. No.
No, 55.
55. Order number such and such.
No, page 56. 22/1/2009.
Yeah. 15 days in a month.
56, not 55.
56. 22nd January 2009.
কত পেজ এটা?
So whatever.
Order number. Order number 34 dated 10/1/2009 in pursuance of the President Director such and such David Ato, Priya Sarkar, Murito Sarkar Ghosh is reported to this correctional for joining as extra temporary female warder on forenoon. He is allowed to join correctional home as extra temporary female warder with effect from in terms of the condition laid down in this appointment letter.
In which page you are reading?
ওটা অন্য ক্ষেত্রে? This is in respect of I have got 289 another matter. এখানে ওর মধ্যেই আছে তো দেখি।
Your appointment letter is at page 56. Why don't you see page 56? We are telling you
56.
56, 57. 57 is gone. There is 58, 59. There is no page 57. Your appointment letter.
Well, give me some accommodation below and to some accommodation below.
No, have a look. This is to old matters, no
Old matter only one.
Just
one or
see,
two
just
days
see page 56.
to work out. Not
Just see
old
page
matter
50.
below.
After you read, after you read.
এটা আলাদা গভর্নমেন্ট অর্ডার
এটা দেখো না তুমি।
এটা আমি দেখেছি এটা বলছি দিস ওয়ান অল আর এটা দেখছি পার করছি গভর্নমেন্ট অফ ওয়েস্ট বেঙ্গল অফিস অফ দি সুপারিনটেন্ডেন্ট কোন্নগর এই কৃষ্ণনগর
22/1/2009.
বলা উচিত না ওইটা কোথায় গেল ওইটা In terms of the memorandum, page 96, your logical is this 1/7/2009, creation of such and post, female warder, and regulation of service. 96, annexure P4. P4. 96. Misplace হয়ে আছে ভুল। Order number হলো তো memo number হলো। এর নাম কি? যেটা করছি এর মধ্যে কোথায় আছে? That's why correspondent কি নাম আছে? অর্ডার নাম্বারটাই পাচ্ছি না।
Yes, what is, we have read page 96.
Then your logical is the page 102. What
is the date of this? What is the date?
Type copy
25th November 2008. 2006.
2006.
25 November 2009, no, 2006, 86.
Sorry, 86.
This is supernumerary post. This is not a
Supernumerary
sanctioned
post,
post.
Your logically the governor has been pleased to sanction that post, my lord.
No, supernumerary posts. These are not posts. They are not
Supernumerary
against
post,
any
my
sanction.
lord, we could understand, my lord, what is the supernumerary post. That's I know, my lord.
Yes.
But here in my lord, as and when the vacancy was there, my lord, they are allowed to join in, my lord.
You have no right. There's no right to be espoused. What about the respondents? They have been regularized.
But subsequently, pending final selections, they were temporarily engaged for 3 months.
No, they have also made a prayer in the OA that respondents 5 to 7 should not be regularized.
Yes.
So have they been regularized?
Yes, brother, we have said so in the affidavit. Because they are not regularized, they have been permanently appointed and in a selection process.
Where have you said that?
Can you see the affidavit affirmed by the affidavit in opposition, affirmed by Shamal Kumar Talukdar on behalf of the respondent of 4. Is it in the part of the record? So let's got it. Shamal Kumar Talukdar.
Paragraph.
Can you see paragraph 6 and 8? What? 6. Deny that any requisition was made to the concerned applicant against vacancy for the post of female order. Said that no selection process was started against any permanent vacancy. The requisition was made for engagement of extra temporary orders only, which was not permanent post. That the respondents have failed to regulate the post salary petitioner for the petitioner have paid their remuneration for the period they have rendered the service and the allegation. Then, can you see paragraph 8? What is the reply? At page 10. It is denied that any memo was issued regularizing the service of the 150 casual workers, and as such petitioners were directed to vacate the barrack. Then the petitioners were service were discontinued with effect from 1st April. There was no hope for continuing staying in the barracks. And paragraph 9, petitioners never selected for any female order. They were appointed on a casual basis, not against any permanent vacancy, and therefore question of their regulation does not arise at all.
Nothing can. Yes, sir.
My reply, your lordship, is
Yes.
Paragraph 5. Affidavit in reply. Affidavit in reply.
Where is your response to paragraph 7?
5, page 9.
May deny, but there is nothing to show that you were appointed against any regular post.
But Milord, I along with the other Milord private respondent to
No,
we have
regarding
but
private respondent, you have not said anything. Regarding private respondent, in your reply, you have not said anything.
but I have made party Milord here in your lawsuit.
Your reply in para 7, they have said that they are not similarly situated. They were working since long back. They have been regularized in July 2009 under a policy of 2004. You have not denied or disputed this in your reply. So that also issue, that is an issue which was in our mind. Therefore, we asked Mr. Mukherjee. They have said so. That they were, it is wrong to say that they were not engaged by following proper selection.
Then your lordship page.
They were regularized. The regularization is at page is P4 to the writ petition.
Your lordship is a page 11 Milord at the bottom. Your lordship Milord, I want to bring to your lordship notice that
Page 11
of my reply.
Reply.
Yes.
Yes. Yes, that they are admitting. There is what is wrong with that? It does not give you any right.
They admitted that the fact that regular is 158 order.
Yes.
As per their own discretion as well as the several others as order of the Honorable Court.
Yes. That does not create any right.
That's why, Milord, we approached before this Honorable Court, Milord, court direction was issued to produce the record.
Not required, sir. Yes. We have seen.
I further state the admitted notice that being the such and such with
It is a Same.
Same.
Appointment letter is also of the same date.
Same.
Same date.
Same.
So,
Same fate.
Huh?
Same fate.
No, is a separate order required. We are asking.
Yes.
Then tomorrow we'll pass you.
Lord, item number 25, your lordship kindly keeps on.